Navigating divorce often involves complex financial discussions. This is where financial dispute resolution, or FDR, comes in. FDR helps reach a fair agreement on asset division. A neutral third party aids in negotiating a settlement. FDR is voluntary but encouraged by the courts. It's about finding a solution that works for everyone. The FDR process is carefully structured to facilitate productive negotiations. Here's a general overview of how it works. First, either party or both jointly can apply for an FDR hearing. This usually happens after the exchange of financial disclosure, a crucial stage where both sides reveal their financial situations openly and honestly. Next, the court sets a date for the FDR hearing, typically lasting half a day. Both parties and their legal representatives attend the hearing. A judge or a specially trained family dispute resolution practitioner presides over the hearing, acting as a neutral facilitator. The hearing often begins with private sessions where the judge meets with each party and their lawyer separately. This allows for open and confidential discussions about your desired outcomes and concerns. Following the private sessions, the parties come together to engage in negotiations. The judge helps facilitate these discussions, encouraging compromise and exploring different options.
Preparation is key to a successful FDR hearing. Here's a checklist to guide you. First, gather all necessary financial documents, including bank statements, pay slips, property valuations, and pension details. Organize these documents meticulously for easy reference during the hearing. Next, complete Form E. Form E is a comprehensive financial statement that both parties must complete. This document requires you to disclose all your assets, liabilities, income, and expenses in detail. Accuracy is paramount when completing Form E, as any discrepancies or omissions can have serious consequences. Before the hearing, clearly define your ideal outcome and any potential compromises you're willing to make. Having a clear understanding of your financial needs and priorities will enable you to negotiate effectively. Finally, explore potential settlement proposals you might offer or be prepared to consider. This proactive approach can save time and streamline the negotiation process.
Section 4. The importance of legal representation. While you're not legally required to have a lawyer at an FDR hearing, it's highly advisable. Family law is complex, and having an experienced solicitor by your side can make a significant difference. A solicitor specializing in family law brings a wealth of knowledge to the table. They can provide expert legal advice tailored to your specific circumstances, guide you through the intricacies of financial disclosure, and ensure you meet all legal requirements. They can also negotiate effectively on your behalf, safeguarding your interests while striving for a fair settlement. Additionally, they help you understand the potential implications of different settlement options. Remember, the decisions made during an FDR hearing can have long-term financial consequences. Having a skilled advocate in your corner can provide invaluable peace of mind.
Section 5. Inside the FDR hearing roles and potential outcomes. The FDR hearing can be emotionally charged. Understanding the process and roles can ease anxiety. The judge's role. As an impartial facilitator, the judge guides negotiations and encourages fair outcomes. Possible outcomes. 1. Full settlement. The ideal outcome is a comprehensive agreement. 2. Partial agreement. The judge provides directions on remaining disputed points. 3. No agreement. The judge will provide directions for the next steps.
Section 6. Reaching a settlement or moving forward. Reaching a settlement at FDR is a significant achievement. It signifies the end of an often challenging chapter, allowing you to move forward with clarity and closure. If you reach a settlement, your solicitors will draft a legally binding document outlining the terms of your agreement. This document, known as a consent order, is then submitted to the court for approval. It's crucial to remember that you're legally obligated to continue disclosing any material changes to your financial circumstances until the consent order is finalized. No agreement, next steps. If you don't reach a full agreement, the judge will issue directions outlining the next steps in your case. This might involve providing further evidence, attending mediation, or participating in other forms of dispute resolution. In some cases, despite all efforts, reaching a settlement proves impossible. Your case may then proceed to a final hearing where a judge will make a binding decision on the division of assets.